All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning, everyone inside and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is case KSC BC 2023-11, the Specialist Prosecutor versus H.Shala.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Good morning, Your Honor. For the Specialist Prosecutor's Office, we have Julie Mann with Case Management, Prosecutor Joshua Hafetz, and myself, Prosecutor Taz Shahabuddin. Thank you.
Thank you, Madam Prosecutor. And I turn to the defense, please.
Good morning, Your Honor. Lawrence van Pijnbroek for the defense, representing H.Shala.
Thank you. I might make a mistake with the pronunciation of your last name, so please forgive me in advance, but it's fun.
Well, in Dutch you pronounce it van Pijnbroek, but with a French or English accent sometimes it's pronounced van Pijnbroek.
Van Pijnbroek. I'll try to do my best, so forgive me if I make a pronunciation mistake.
Both are good for me, Your Honor. Thank you.
Thank you. And now I turn to the registry, please.
Good morning, Your Honor, and good morning, colleagues. Jonas Nilsson, Deputy Registrar for the registry today.
Thank you, Mr. Nilsson. And for the record, I note that Mr. H.Shala is also present in the courtroom. And I am Nicolas Guillou, pretrial judge for this case. On 13 December, I scheduled the first status conference in this case for this Friday. My goal today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss the status of the Specialist Prosecutor's investigations, the estimated amount of documentary and testimonial evidence the parties will bring to trial, issues related to the disclosure of supporting material to the indictment, which is what we call the Rule 1021A material, the additional material intended to use for use at trial, which is the Rule 1021B material, the evidence material to defense preparation obtained from or belonging to the accused, which is the Rule 1023 material, the exculpatory evidence, the Rule 103 material, and the protected material, which is the Rule 107 material. Then we'll also discuss the procedure for disclosure, the redaction regime to be adopted for the present proceedings, and the special prosecutor's joinder request, and finally, any other issues the parties may wish to raise. I thank the SPO for its submissions. And I also note that scheduling order F00017 was notified to the defense with a slight delay, and that made it impossible for you to file written submissions. But please draw my attention to any point for which you need more time so that we make sure that you have the opportunity to make submissions. I will invite the parties to present their views in a concise fashion about each item in the agenda, which I will address individually. And as usual, I remind the parties to give prior notice should any submission requires the disclosure of confidential information, though we can move into private or closed session. Let me first move to the general questions. Before I give the floor to the parties, I wish to remind them of the general principles of disclosure in the legal framework of the specialist chambers. Disclosure is an inter partes process in electronic form, organized and facilitated through the registry's court management system. Disclosure shall be a priority for the prosecution at this stage, and the parties shall disclose evidence of true relevance to the case and not the greatest volume of evidence. In view of the publicity principle, evidence is registered as public unless there are reasons to classify otherwise. The disclosing party determines the appropriate level of classification of evidentiary items on a case-by-case basis. I would first like to hear from the SPO on this topic and the agenda, notably the status of its investigation, the type of evidence it intends to use in the proceedings, and how many witnesses it intends to call at trial. Madam Prosecutor, you have the floor.
Regarding the investigation, it is ongoing. However, we foresee that there are just a small number of additional steps at this point involving the review of evidence already in our possession that we estimate will take into January of 2024. Of course, I will say that with the caveat that if additional evidence comes to light, we would, of course, need to consider that. And so we leave room for that eventuality. With regard to the type of evidence that we intend to present at trial, we have documentary evidence that includes records from seized telephones, specifically mobile telephones, call data records, transcripts of various statements, as well as official notes from witness contacts. We have provided in our written submission a chart indicating the specific volumes of different categories of information that will form part of our 1021A material, and I'm happy to provide any additional detail that the court may require. Regarding the number of witnesses, the SPO relied upon the statements of 2 witnesses in connection with its confirmed indictment. And it intends to present their testimony at trial currently. That is currently the extent of our witness list. That being said, we would reserve the right to call additional witnesses if such testimony would be necessary for the authentication of any of our other evidence.
Thank you, Madam Prosecutor. Let me turn to the defense. Do you have any submissions on this general point of the agenda? Counsel.
Thank you, Your Honor. Before making some general remarks regarding the disclosure, I have a question for the court regarding a possible preliminary issue, but I don't know if it's the time now or maybe at the end of the session. It regards the plea of Mr. H.Shala. As you will have noticed at his initial appearance, he has chosen not to enter a plea. Given the very limited information he has been transferred to, up to date, he has conferred to me a very clear position at this moment, and he would like to confirm that position in court today. So I don't know if it's possible. I'm aware it's not a disclosure-related issue, but I would like to point it out at this moment.
Do you mean that your client intends to plead today? This is, do I understand it correctly?
Just to make a formal statement regarding the plea, as according to the rule foreseen.
Because I was planning to set another hearing for the plea in January, after the disclosure of the 1021A material. So we could actually have the plea of your client today. I don't see any problem. We'll ask the other party, but I don't see this as an issue. Or we can have the plea, the formal plea in January, and have a statement of your client today. I'm in your hands.
As I understood from him, I will of course leave the final decision in his hands, but as I understood from him, he would like to make that, he would like to express his statement today regarding the plea.
His plea today. Then we will probably break at some point, and then we will continue with the plea of your client a little later in the session, after we've dealt with disclosure. I will just ask the SPO if they have any opposition to having the plea hearing today.
The SPO has no objection to that, Your Honor.
So we'll proceed with disclosure for now, and in a second part of the status conference, we will have the plea hearing then. Thank you.
So, if I could just make some general remarks regarding the proposed timetable for disclosure. I have taken notice of the proposed dates for disclosure, which I see strictly adhere to the limits foreseen in the procedural rules. But according to the defense, limiting them seems justified. and necessary with the aim of making the defense of H.Shala as effective as possible within the shortest possible time frame. So the defense would ask in a general way that all these dates would be shortened. And if I may make some short clarifications regarding this request, the defense has taken notice of the intention of Your Honor to adopt a speedy pace for the conclusion of the pre-trial phase, as expressed in the order setting the date for today. And we acknowledge that, of course, and we are also thankful for the fact that this first status conference is being organized so short after the initial appearance. But at the same time, we are hopeful that the exchanges of today will allow for a swift disclosure. And with that, I mean disclosure ahead of the deadline provided for in the applicable rules. And according to the defense, such a short time frame, a shortened time frame, seems justified for three particular reasons. First, since the arrest, H.Shala has been given only very limited information about the actual, concrete, precise elements on which the suspicion for the alleged crimes is based. I am aware there's of course the brief indictment, there's also the confirmation decision of Your Honor, but both are of course heavily reliant on the supporting material which has not been disclosed so far. Second, a speedy disclosure is also key to the issue of detention on remand. And a speedy disclosure would allow the defense to assess possible motions in that respect. But surely such motions, such as the decision on the pretrial detention itself, should not be taken lightly. That is the position of the defense. And before considering maybe submitting such motions, the defense intends to carefully examine all the relevant material, and this further underlines the need for an expeditious disclosure. And thirdly and finally, this case is, of course, as we have also just heard from the prosecutor's office, is quite limited in size, especially compared to other cases. Both regarding the number of witnesses the SPO is expected to call, as regarding the extent of the supportive material itself. So, concluding, Your Honor, regarding these general remarks, I dare to submit that I may expect, or that it may be expected in such circumstances, that the SPO makes a reasonable effort to disclose or to speed up the disclosure process as much as possible. And I thank Your Honor for taking these observations into account when drafting your framework decision. I thank you.
Thank you very much, Counsel. Madam Prosecutor, we're going to discuss each deadline separately because we will address each category of evidentiary material separately. But do you have any comment on the general remarks of the defense, please?
Thank you, Your Honor. As set forth in our written submissions, the SPO has proposed a very aggressive schedule for itself in terms of disclosure. We contemplate everything being to the defense up through 1023 material as of the 26th of January, and the submission of the SPO's pretrial brief on 2 February. I'll point out that we are currently heading into a court recess, which begins at the close of business today, and that our next working day will be the 8th of January. So that is the reason for which we propose that our 1021A material, as per the rule, be due 30 days from the date of the initial appearance, which we would date as 11 January. To the extent possible, the SPO is happy to produce materials, disclose materials in advance of the various deadlines it has proposed. That being said, we also await the framework decision, and in particular, because all of our materials will require some limited number of at least standard redactions, the decision on protective measures, the SPO has submitted a request regarding the adoption of protection measures and a protocol regarding the contact with witnesses.
Thank you very much. Let us move to the next item in the agenda, which is the supporting material to the indictment. So we will go into detail about the deadline for each category of material. So I take note that the SPO intends to disclose material falling under Rule 1021A by no later than 11 January 2024. I also take note that part of the SPO's material under this rule may require protective measures. I invite the SPO to give further submission on the disclosure of this category of material, notably the overall amount of this category of material, whether translations into Albanian of witness statements from whom the SPO intends to call to testify at trial have been finalized, and any other detail the SPO wishes to provide. And then I would also ask the SPO if it sees any possibility to disclose this category of material earlier, given that this is probably the most important material for the defense at this stage, and it also triggers a series of deadlines, especially preliminary motions, which is also something that has potentially an impact on the joinder. Madam Prosecutor, you have the floor.
I'll begin by addressing the volume of materials, which I think you'll find throughout my remarks today is not extensive. But with regard to 1021A material, our total number of items is 32, and that includes 2 witness statements, 3 statements obtained from the accused, as well as a number of reports and some audiovisual material and other documents. With regard to the deadline, there are some limited number of redactions that we would need to make. So a decision on protective measures, for instance, would assist us in making early disclosure, but to be entirely frank with the upcoming recess, I'm not sure how far in advance of the 11 January deadline we have proposed we could make earlier disclosures. That said, we will certainly endeavor to put together materials for the witnesses on as expedited a basis as possible.
Do you see any possibility to disclose material that do not need redactions earlier? Because I understand for material that requires redactions, but if no redactions is required, it should be pretty straightforward.
Yes, we can certainly work towards that by beginning, our processing immediately. I hesitate to commit to any specific dates at this point, just in light of the recess, but we will certainly endeavor to do so and can do so. The other thing I will mention, which I think would be a key piece of evidence for the defense to begin examining, is the forensic images of phones that have been seized from the accused and from his co-perpetrators as identified in the confirmed indictment. That material is indeed ready and available for the defense to pick up, just subject to coordination with our office.
Then I invite you to coordinate with the defense so that it can be done swiftly. Thank you, Madam Prosecutor. Counsel, please.
Thank you, Your Honor. Specifically regarding the 1021A material, the defense would really like to stress the need for a speedy disclosure. You have already asked the question I had prepared, namely, if it would be possible to immediately, as soon as possible, disclose the material not needing redaction. Of course, I understand the aspect of the recess. The recess is an exceptional circumstance, but such is also the situation of my client, the pretrial detention in particular. So I would really like to stress the need for an early disclosure regarding this type of material. I would intend to be a bit more lenient, as I may say so, regarding the other types of material, but as you have already pointed out, this is really an essential part for the defense in order for us to start building our defense. So I would like to, I will not reiterate my observations of earlier, but I would like to stress them. I would like to ask the prosecutor if it sees a possibility to disclose this type of material, for example, in a rolling process, before the recess, because that's, as you will have understood, Your Honor, the essence of my request regarding this material. I thank you.
Thank you, Mr. Van Puyenbroek. We are in agreement. The SPO will do its best to disclose the 102.1a material, the material without redactions as soon as possible, and with redactions no later than 11 January, but on a rolling basis as soon as you have the possibility to do so. So the defense is in a position to make any submissions, especially on detention. Let us now move to the Rule 102.1b material, which is the material intended to use at trial. I take note that the SPO proposes to disclose additional material falling under Rule 102.1b of the rules by 19 January, or in any case no later than 30 days prior to the opening of the SPO's case. I invite the SPO to give any further submissions on the estimated amount and type of material it intends to disclose, the redactions that will be required, and any other details the SPO wishes to provide in relation to this category of evidence. Madam Prosecutor. Microphone, please.
Thank you, Your Honor. The volume of the Rule 102.1b material the SPO plans to disclose is currently 103 items, and the total number of pages is almost 6,000. It consists of approximately 15 witness statements. So that's the broad contours of what we intend to disclose. I note that we propose to make that disclosure approximately 1 week after the 102.1a deadline. Again, the material will consist of documentary evidence, such as records from seized mobile telephones, audiovisual materials, as well as call data records. And as I mentioned, the forensic images of the phones of the accused and the two co-perpetrators identified in the confirmed indictment, who are the accused in Case 10, that material is already available for the defense to collect and examine. The only additional comment I would make at this time is that it is possible, given the ongoing investigation, that additional evidence may be required to be disclosed pursuant to Rule 102.1b, and that those materials may also then require translation, and which we would propose to complete within the time frame that we have proposed.
Thank you, Madam Prosecutor. Mr. Van Puyenbroek, do you have any submissions on this material?
I have no particular submissions other than those made in a general way, Your Honor, in the beginning. Just maybe one question for clarification by the SPO. It has mentioned up till now twice the aspect of an ongoing investigation. It has made clear that it would be short, that it expects to be short, but could it give some more clarification, somewhat more clarification, of course, without going into detail? I have understood this case is linked to another case, 2023-10. There the investigation has been going on for a couple of months. I've read some procedural documents relating to that case. There, in October 2023, it was foreseen that the investigation would be continued for 3 months. We are now 3 months further. So I would like to hear if that's, of course, possible of the SPO, if it could give a more precise indication of the time frame for the conclusion of the investigation. I thank you.
Thank you, Mr. Van Puyenbroek. I will let the SPO respond on this, but I think you mentioned earlier that you were not expecting investigations to go beyond the month of January.
That's correct, Your Honor. Currently, our additional steps related to the ongoing investigation are limited in nature and involve the examination of evidence, specifically phones, already in our possession. Our timeline depends in part on the court, and we will proceed as expeditiously as possible. But what I will say is that our further investigation of this evidence is targeted, and so we do not anticipate any issues with concluding our investigation in the first month of next year.
Thank you, Madam Prosecutor. Let us now move to the next item in our agenda today, related to evidence material to the defense preparation, which is the Rule 102.3 material. I would like to remind the SPO that disclosure or inspection of evidence, such as statements, documents, photograph, or tangible objects material to the defense, must be disclosed without delay. The detailed notice of such material must include not only information the SPO assesses to be potentially material to the defense preparation, but any material and evidence in the SPO's possession which has not been disclosed under Rule 102.1a and b and Rule 103, and which is relevant to the case. I also remind the parties that disputes as to the materiality of the information, as claimed by the defense, must be submitted immediately to the pretrial judge for resolution. I take note that the SPO anticipates providing the defense with a detailed notice of Rule 102.3 material by 26 January 2024. So I invite the SPO to indicate for this category an estimation of the type and amount of material, the redactions that will be required, and any other details the SPO wishes to provide. Madam Prosecutor. Microphone, please.
With regard to Rule 102.3 material, the SPO will, of course, operate in accordance with the rules. Regarding the nature of the material, we currently estimate that the items will number less than 50, and possibly that it will also consist of approximately 55 pages of materials, though, of course, oh, I'm sorry, let me revise that on the record. I'm sorry, all I'm prepared to say, actually, with regard to the Rule 102.3 material is that we have less than 50 items currently identified, but that our review is ongoing. And so I would ask for some latitude in that regard, though we certainly don't anticipate that number ballooning. And what we have identified will not require further redactions. So we fully anticipate being able to meet the deadline we have proposed as to these materials.
Thank you, Madam Prosecutor. Mr. Van Puyenbroek.
I have no particular observations at this point, Your Honor.
Thank you very much. Let us now move to the Rule 103 material, which is the exculpatory evidence. I remind the SPO that it must be disclosed immediately to the defense as soon as it is in its custody, control, or actual knowledge, and which may reasonably suggest that the innocence of the accused or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence. Disclosure of exculpatory evidence is a continuous obligation, subject only to protective measures where necessary. I note that the SPO is continuing its review of Rule 103 material. The SPO indicates that approximately 14 items have been identified, which are being prepared for immediate disclosure. I invite the SPO to indicate the amount and type of exculpatory material to this day, whether redactions will be required, and any details the SPO wishes to provide. Madam Prosecutor, please.
As Your Honor mentioned, currently the number of items that the SPO has identified as falling under Rule 103 number at 14. We expect that those items comprise approximately 55 pages. Amongst those items, there are no statements or reports or transcripts or audiovisual material. It purely consists of other types of documentary materials, which may prove exculpatory. And those materials will require redaction, but are being prepared for disclosure.
Thank you, Madam Prosecutor. Counsel, do you have any submissions?
I have no particular observations at this point, Your Honor. Thank you.
Thank you, Mr. Van Puyenbroek. Let us now move to the protected material. I take note that at the current stage, the material that the SPO intends or has to disclose pursuant to the rules do not require Rule 107 clearances. Madam Prosecutor, would you like to add anything on this point?
Only that should any material be identified which would fall under Rule 107 restrictions, the SPO will promptly notify the court.
Thank you, Madam Prosecutor. Counsel?
Observations, Your Honor. Thank you.
Thank you. Let us now move to the procedure for disclosure, notably the use of the case-specific categorization in legal workflow for material falling under Rules 102.1a and b and Rule 104.1, 5, and 6 at the time of disclosure of each batch of such material. The SPO indicates that it can apply the case-specific subcategories in legal workflow as indicated in Scheduling Order F00017 in paragraph 21. And if the defense needs a bit more clarification, I will read these categories in paragraph 21. The subcategories suggested in the scheduling order are 1. Count 1, Count 2, Count 3, under the standard category offenses. 2. Commission, co-perpetration, agreement, assistance, and attempt, under the standard category alleged conduct of the accused. And 3. H.Shala, under the category accused. Madam Prosecutor, do you want to add any specific details or are you satisfied with this proposal?
The SPO is entirely satisfied with the proposed categories, Your Honor.
Let me now turn to the defense, and to give a bit of context, these categories are aimed at helping the receiving party so that it can immediately understand what when each piece of evidence is relevant for what aspect of the case. Counsel.
Thank you, Your Honor. The defense can agree with the proposed categorization.
Thank you very much. I take note of that an agreement has been reached, and as a result, I will issue a first oral order. I hereby order the adoption of the case-specific subcategorization to be applied in legal workflow as indicated in Order F00017, paragraph 21. This concludes my first oral order. Now I invite the parties to give further details on the following questions, notably whether the parties can agree on a model consolidated disclosure chart that satisfies the requirements of Rule 109C of the rules, and whether the SPO and the defense agree to provide each other with a consolidated disclosure chart at the time of the submission of the SPO pretrial brief and the defense pretrial brief, respectively. Madam Prosecutor.
The SPO agrees to the mutual provision of Rule 109C charts and would simply ask, as indicated in its submission, that those charts be, or that its chart be due 15 days from the filing of its pretrial brief in order to avoid any error given the detail necessary in order to properly populate the chart.
Thank you, Madam Prosecutor. Let me turn to the defense. Mr. Van Puyenbroek.
Thank you, Your Honor. The defense can be brief at this point. It can agree with the proposed procedure. Thank you.
Thank you very much. I take note of the agreement of the parties on this matter. Now let us move to the next item in the agenda, which is the redaction regime. In adopting a redaction regime, it is necessary to ensure the efficiency of the disclosure process, while striking a balance between the duty to protect the interests of the victims and witnesses and upholding the rights of the accused. In their submissions, the SPO agrees to adopt the redaction regime applied in case KSC-BC 2023-10. I invite the SPO and the defense to make submissions on this topic. Madam Prosecutor.
The SPO agrees to adopting the redaction regime set out in Case 10.
Thank you, Madam Prosecutor. Mr. Van Puynbroek.
Defense also agrees, Your Honor. Thank you.
Thank you, Counsel. I take note of the agreement of the parties. Let us now move to the issue of joinder of cases 11 and 10. The SPO filed a request for a joinder of case 11 with case 10, namely the Specialist Prosecutor versus Sabit Yanouzi and Ismet Bakhtiari. This is filing F00016. The SPO equally filed such a request in case 10, which is filing F00132. As a preliminary matter, I note that, pursuant to the rules, the deadline for the defense to respond to the SPO joinder request falls during judicial recess, which starts on Monday, 18 December. As a result, as I did in previous instances, I intend to modify the briefing schedule to give adequate time to the defense to prepare its response. In this context, I also note that yesterday, during the STIR status conference in case 10, I instructed the SPO to file a proposed joint indictment of cases 10 and 11, as well as a proposed joint Rule 86.3 outline, which would also entail the disclosure of the material underlying the proposed joint indictment. Before I proceed, I invite the SPO and the defense to make submissions on this topic. Madam Prosecutor, you have the floor. Basically, my proposal is to align the briefing schedule and the updated indictment to what has been decided yesterday in case 10.
Certainly, indeed, the SPO filed its joinder request at the earliest possible opportunity, precisely with the intention in mind of aligning the cases as quickly as possible, and the disclosure the disclosure schedule that the SPO proposes today indeed brings the cases into an alignment as of 26 January, meaning that the same disclosures at that point will have been made in both cases, and the hope is that from that point forward, the cases can move together apace. With regard to the what was set forth yesterday in the case in case 10 regarding the filing of a proposed joint indictment, the SPO would simply propose to file the same in both cases simultaneously.
Thank you, Madam Prosecutor. Mr. Van Puynbroek.
Thank you, Your Honor. The defense has nothing to add at this moment. Thank you.
Thank you, Counsel. I will now issue a second oral order. Having heard the parties, I find it appropriate to order the SPO to file a proposed joint indictment of cases 11 and 10, including the Rule 86.3 outline and the supporting material. I further find it appropriate to vary the time limits prescribed by the rules to respond to the SPO joinder request, which is filing F00016. Accordingly, I hereby order, first, the SPO to file a proposed joint indictment of cases 11 and 10, including the Rule 86.3 outline and the supporting material, by no later than 12 January 2024 at 16 hours. Second, the defense to respond to the SPO joinder request, which is filing F00016, by no later than 19 January 2024 at 16 hours. And the SPO to reply by no later than 26 January 2024 at 16 hours. This concludes my second oral order. Before we break for probably 15 minutes or so in order to have the plea hearing. I would like to ask the parties whether they have any other issues they would like to raise today at the status conference. Madam Prosecutor.
Nothing from the SPO, Your Honor.
Nothing from the defense either, Your Honor. Thank you.
Thank you, counsel. And the registry, please.
Your Honor, you had asked us to make some submissions on reclassification of certain filings. Would you like them to be done now?
Absolutely.
Then I will do them right now. The registrar does not object to the reclassification of the following filings to public: F8, F11, and F12. We further submit that Annex 1 to F12 should retain its confidential classification, as it contains personal details of the duty counsel. As regards Annex 1 to F11, the registry will file a public redacted version of the annex as soon as the core filing, so that is F11, is reclassified as public. And finally, with respect to F15, the registrar has no objection to the report being reclassified as confidential, so that it can be made available to Mr. H.Shala's duty counsel. And we'll be submitting confidential redacted versions of Annexes 1, 2, and 3 to this filing. And we aim to do so today, as you have asked us to do. In addition to that, with regard to F15, we will also be filing a public redacted version of the core filings, but we ask, with your permission, to do that after the recess. Thank you very much.
Thank you, Mr. Nielsen. This is noted. We will now break for approximately 15 to 20 minutes, and we'll resume with the plea of Mr. H.Shala. The hearing is adjourned.
All rise. All rise. Please be seated.
Before we move to the plea, I will issue an order related to the registry submissions just before the break. I will now issue my third oral order. Having taken note of the reclassification request from the registrar, I hereby order the reclassification as public of filing F00008, F00011 without annexes, and F00012 without Annex 1. I further order the reclassification as confidential of filing F00015 without annexes and lift the ex parte marking. This concludes my third oral order. Let us now move to the plea. Mr. H.Shala, during your initial appearance on Wednesday, 13 December, I informed you of the need for you to plead guilty or not guilty on the charges brought against you in the confirmed indictment. In the exercise of your right, you indicated that you did not wish to enter a plea immediately at the initial appearance. I reminded you that, pursuant to Rule 92, you must enter a plea within 30 days of your initial appearance, and that if you fail to do so, I will enter a plea of not guilty on your behalf. Mr. H.Shala, in a few moments, I will ask you to enter a plea of either guilty or not guilty on each of the 3 charges in the confirmed indictment. I would like to remind you that it is a very important decision. Should you wish to plead guilty on all or some of the counts, the proceedings in relation to those charges will go directly to a trial panel. There will be no evidence presented and no discussion on your guilt or innocence. The trial panel would simply determine whether your guilty plea was voluntarily made, whether you understand the consequences, and then move to sentencing. Alternatively, should you wish to plead not guilty on all or some of the charges, the pretrial proceedings will continue in relation to those counts, with a view to preparing for those counts to be litigated before a trial panel. At trial, the panel would admit evidence, hear from witnesses, and receive submissions from the parties. The trial panel would then decide whether the prosecutor has proven your guilt on those charges beyond reasonable doubt. I will now ask you to enter your pleas on each of the 3 charges in the confirmed indictment. I recall that these charges were already read out to you by the court officer during your initial appearance. Mr. H.Shala, before you plead guilty or not guilty on each charge, do you want the charges to be read out again today by the court officer?
No, Your Honor.
Thank you, Mr. H.Shala. I will now ask you about your plea. Mr. H.Shala, how do you plead on count 1, charging you with the crime of obstructing official persons in performing official duties by serious threat?
Absolutely not guilty.
On count crime of obstructing official persons in performing official duties by participating in the common action of a group?
Not guilty.
How do you plead on count 3, charging you with the crime of intimidation during criminal proceedings?
The same. Absolutely not guilty.
You may be seated. Mr. H.Shala, you have chosen to plead not guilty on all counts, so the pretrial proceedings will continue with a view to preparing this case for trial, pursuant to Rule 95. I would like to inform the parties that I intend to hold the next status conference the week of 5 February. In relation to the modalities of participation, I recall that should counsel of the accused wish to participate via video conference, written notice shall be sent via email to the registry 24 hours in advance of the relevant hearing so that arrangements can be made. Such notice should include the written consent of the accused, as the defense did for the status conference. You will receive a scheduling order that will include the agenda before the status conference. I invite the parties to make written submissions if they would like to raise any specific issues in the next status conference that is not already in the agenda. Do the parties have anything to add? Madam Prosecutor?
Nothing from the Specialist Prosecutor's Office. Thank you, Your Honor.
Thank you, Madam Prosecutor. Mr. Van Puyenbroek?
The defense has nothing to add, Your Honor. Thank you.
Thank you, Mr. Van Puyenbroek. Mr. Nielsen?
Nothing further, Your Honor. Thank you.
Thank you very much. This concludes today's hearing. I thank the parties and registry for their attendance. I thank, as usual, the interpreters audiovisual technicians, stenographers, and security personnel for their assistance. And I wish everyone a good holiday break for Christmas and New Year's, and we will see you in the New Year. The hearing is adjourned.
All rise.